So good morning, ladies and gentlemen. It's a pleasure for us to be here today. My name is Madame Picotin. I'm a French lawyer, and I introduce you my partner, Ophélie Rodriguez. Our law office deals case files involving cult and mind control only for the victims. The subject of our talk today is the role that a lawyer plays and the proof he provides in the eyes of the victim and under French jurisdictions.
So, we have in France a Latin saying, idem est non esse et non probare, which literally means in English, if you cannot prove your right, it stipulates that you have none. In the overworld, this adage highlights the crucial significance of proving one's rights in justice. If the plaintiff fails to give proof, his request won't come to a resolution and will be rejected. In terms of cases involving cult and mind control, demonstrating and collecting proof is neither simple nor easy. In the United States of America, the lawyer plays a key role in supplying evidence. It is totally different regarding the French jurisdiction, where we must tell the difference between civil and criminal proof.
It is traditionally admitted that in terms of criminal acts, that the proof is free, which allows the lawyer to add audio recording, to make secret videos towards incriminating people, etc. Unlike civil acts, where the proof is written and reliable. Nevertheless, last year, French case law attempted to make the way we collect evidence more flexible while accepting to establish proportional control, to balance the rights to prove and the antinomic rights involved. For example, the case law plenary assembly in 2023, the Court of Cassation considered that the illegitimacy of the disloyalty of obtaining or collecting proof during a civil process does not necessarily lead to remove debates. In the end, the judge is supposed to appreciate whether a given proof may harm the impartiality of the procedure by and large, by balancing between the right to proof and the antinomic rights involved. The right to proof can explain the production of elements that may harm other rights of proof, provided that this fact should be essential to be carried out in the infringement being proportional to the objective expected.
As far as cases involving cult are concerned, taking action in a criminal complaint or in a family setting procedure, the most important thing in case law is that all kind of proof, all kind of evidence can be used. At worst, the proof that may be considered as illegal or unfair would not be rejected on compulsory duty, and if the opposing party raises the rejection of the proof and the magistrate accepts it, then the latter examines the case file by taking into account the elements of the proof.
Contrary to the typical American lawyer, the French lawyer doesn't take part in what we call the adversarial procedure, which consists of asking the exchange of documents to send and replay to questioning to gather statements from the witnesses. It is indicated that the French lawyer cannot directly specify to the witness which questions will be asked to him, and it is strongly recommended to the lawyer not to communicate with the witness except during the day of the trial, where he can ask questions only before the court.
In theory, only the police are able to collect elements of proof and exploit them. However, the lawyer actually plays an effective role at the beginning of the inquiry, either to overcome potential failings of the investigators' services, or the possibility that they may have additional and relevant elements to supply. At this stage of the procedure, the lawyer has to play an effective part in the collecting of proof during the preparation of cases, as well as the treatment of proof when the hearing takes place.
So we will see the collection of proof in the preparation of the case file. In the cases involving mind control and cults, the approach to the case will be different depending on whether we are armed by the indirect victims, such as concerned family members, or by the direct victims themselves. First of all, we will deal with the collection of proof during a referral from the indirect victims. Secondly, we will talk about the collection of proof of a referral from a former member. When the law office is chosen by the relatives of the victims, more often than not, they are no longer in direct contact with the victims. Most of the time, any complaint is filed at the court. We offer to write the complaint for them. All the proof is added to the complaint, which is then referred to court. In the case file K, we have engaged a private investigator in order to identify what the cult leader did with its victims and specify the link as well. In the case file R, the indirect victim showed all the text exchange between their adult son and the manipulator. The mother found evidence on the family computer, which were used as proof against the cult leader.
Generally, it is essential we recommend the relatives to keep all the text and email exchanges with the victims, gather testimonies from the relatives, having the same assessment, and finally organize a private investigation in order to find out other former sectarian victims. It is also possible to denounce the cult leader to the milieu and to association which help victims for the simple reason that they may register others and take all cases to justice. In the case file M, closer to familiar circle, the father of the child is precisely in the court. Then we intervene for the mother, who the cult leader is himself the grandfather of her child. To convince the judge about the danger faced the child, the CCMM, Association Against Mind Control, wrote us a letter explaining all the action carried out against its group and describe how it's dangerous for the child. For example, the weekend of conversion therapy for fight the homosexuality. Always about the same case file. Our client, via social networks, succeeded in getting in touch with a journalist who infiltrated the group and obtained proof that we gave the judge. So, to speak, there is no need to neglect the social networks in terms of collecting evidence.
When we are by a victim directly, the fact that he is himself a witness of his own situation allows us to collect significant information and to know about the link between members of the same cult group. For example, in the case file DB, we assist a victim who explained that the cult leader coached her as well as other victims. Another victim has been added to the procedure for the later had reported to the Mivilude his experience. By the way, the Mivilude itself had transmitted different descriptions operated within the organization and had carried them out to the law. By discussing with the victim, we can obviously take into account the possibility to require proof from the victim without difficulty. It is a demanding task, very frustrating, because there is loss between proof the victim describes and what we have in hand. However, the most significant thing is always to gather enough proof so as to specify the infringement and finally sentence the cult leader. For instance, the victim may have several phone records from the cult leader or a member of the group, which can be used to show harassment. Also give us the list of the SMS, emails within the cult, including rules and regulations, sanctions, experience, and any other written record of the daily activities.
In the case file S, the client handed us over photographs of the group, all dressed in white light druids during the rituals. When we completed the file with all the elements supplied in order to back it up. In the case file G and H, the search revealed that the investigators had collected more than 800 pornographic films from the members submitted to the cult leader on order. Sorry for not showing you the videos. Trust me, it's really horrible. In the case, in the case file A, different furniture was seized by the investigator. For example, a throne on which he stated to preach, a scepter, but also being painted by a member, which shows a scene of Greek mythology, and each portrait had the same face of member from the same group. The lawyer who made aware of the existence of the image and films must ask the judge to proceed via such warrant. On the one hand, it is essential to lead the victims to medical assistance to help them to reassert their self-control or self-reliance. On the other hand, we must justify the need for reconstruction in jurisdiction and therefore prove the psychological damage.
As regards the victims, the psychological report allows to explain the notion of mind control and the repercussions of in their lifetime. Generally, the judge in charge of the investigation organizes psychological and psychiatric valuations for this purpose. If there are not any, the lawyer asks for them. Once the reports are submitted, the lawyer is able to evaluate and ask complementary questions about them, and if need be, demand a second opinion. It is not enough to sentence a cult leader by a sample valuation. The accumulation of proof may lead to it.
Now, we will see the evaluation of the proof during the hearing. At the beginning, all the proof collecting in progress is supposed to be reviewed during the hearing, which is an oral procedure. The lawyer must refer to it during the proceedings. Moreover, during the criminal hearing, witness for the defense can be put forward in the same way as witnesses for the victims. When we name witnesses, they should be sure of their position. It is unhelpful to question a witness who is uncertain. In the case G and H, when the hearing of appeal was taking place, the court leader named witnesses, one of whom was aware of the situation of mind control in which he was held and turned against the cult leader while asserting his guilt. To support the victim's position, it is fundamental to put forward some witnesses who lived the same schemes or machinations of the cult leader. At the same time, it is essential to hear from the relatives who saw the victim's behavior radically change.
In all the case files involving cult and mind control, that noticed that the cult leader himself often relies on witness testimony from his one cult followers. In some instances, the lawyer of the plaintiff may be unwilling to deal with all these kinds of witness. Nevertheless, it can be revealing to see them address the bar with identical testimony, body language, and the same appearance. Personally, they feel targeted by the complaint, although they are considered as witness, and defend excessively the cult leader to whom they pledge allegiance. In the case file D, the cult leader has mentioned 3 witnesses. For one among them answered to a question at the courthouse by adding words like in accordance with the opposing party. The court has immediately raised and underlined that it was not part of the trial, and there was not an opposing party.
Also, during the hearing, the body language of the witnesses is all instructive that we can see in case file G and H. The people in defense place themselves one by one, respecting the rank in the group and behind the cult leader. They use the same phrases and expressions, the same robotic body language. Like the cult leader, they are without empathy toward the victims. There is an aberration of affect, and they defend the cult leader by all means, while considering him as a victim. On the contrary, the prosecution witnesses are more natural, what reveals a sense of authenticity.
During the hearing, the specialist psychologists and psychiatrists can be questioned by the jurisdictions or by the party. Speak as long as possible about the reports and potentially deal with some question profoundly. Some audios and films may be broadcasted on demand of jurisdiction or the parties. In the case file J and H, the judge were supposed to review 800 films and asked the broadcasting of a significant video during the hearing. Actually, one of the members, who is always in the group, filmed himself in the front of the camera by speaking to the cult leader. By the way, she was crying and in a state while thanking the cult leader for a sexual relationship they had together.
For which reason, the lawyer has a tedious task to specify the proof. The lawyer has absolutely to know the case file so as to compare the prosecution witness and the cult leader with the contradiction that came out of the different proof, as well as their own examination. Despite the objective proof in such case file, the cult leader is their own defense make believe that our law office has entirely created the case file. However, it is evident that the argument is not considered, for the simple reason that the cult leaders are always sentenced.
During the whole stage of case file management, the collection and the treatment of proof is very tedious. In spite of the efforts made by the cult leader to keep everything secret within the group, nonetheless, there is always leaking of elements with the lawyer twice at the end. The law office take drastic steps to communicate on the fight against cult cases as much towards the general public via internet, social networks, as the professionals, many lawyers regarding this issue. This communication, sharply criticized by the cult leader, is beneficial. That's why in the case 5A, a victim conducted research on the cult leader. And when she found our website, she understood what we defended a victim of the same cult. In these circumstances, we have asked the new victim to build her own testimony at the advantage of the first victim. So thank you for your attention. I'm sorry for my English, my partner also. But maybe, do you have any questions?